Today on The Right Slant, we're going to discuss how firearms can be confiscated in Delaware and how someone might get their firearm returned. We'll walk through the law clearly and factually. As always, if you find this helpful, please like, subscribe, and hit the notification bell to stay updated on our firearms rights information. First, let's list some of the ways your gun might be taken by law enforcement in Delaware. A court issues a protective order, for example, a domestic violence protective order or a red flag type order, requiring you to relinquish firearms. A law enforcement agency seizes firearms under a risk-based statutory process, where you're deemed dangerous to self or others. A firearm is taken in connection with criminal proceedings, for example, when you're charged with a weapons offense or prohibited from possessing firearms. A firearm remains in the custody of a law enforcement agency because you requested its return and the agency denies the request or you failed to act. Now, let's walk through Delaware law to understand what happens and how the return process works. In Delaware, the key statute for the return of deadly weapons, firearms, or ammunition held by a law enforcement agency is found in 11 Delaware Code Section 2311. Any person requesting the return of a deadly weapon or ammunition must prove ownership and that they are not otherwise prohibited from possessing it. A third party also has the burden of showing legal ownership by gift, sale, devise, etc. If the weapon remains unclaimed for 6 months after notice, the agency may dispose of it, including transferring to a federally licensed dealer or destruction. If the agency denies the request for return, the denied person may file a petition in court for return of the property, and the agency may not dispose of the weapon until final adjudication and appeal deadline expire. Delaware also has a process for firearm seizure when someone is deemed dangerous to self or others. This is found under 11 Delaware Code Section 1448C. Here's how it works and how return can happen if law enforcement receives a report and determines there is probable cause that the individual is dangerous to self or others and in possession of firearms or ammunition. The agency must seek an order from the Justice of the Peace Court to relinquish firearms/ammo. The court's order can require relinquishment to a law enforcement agency or allow voluntary relinquishment or transfer to a designee not residing with the individual. If the basis for the order is later removed, for example, you are no longer subject to the prohibition, then the firearms/ammo must be restored in a timely manner without the additional requirement of another petition under Section 1448A subsection J. The statute specifically allows someone to petition the court for an order to return firearms or ammunition by establishing by a preponderance of the evidence that they are no longer a danger to self or others. Here are practical steps someone should follow if they want to seek return of a firearm in Delaware. Step 1. Determine why the firearm was confiscated or is in law enforcement custody. Was it due to a protective order, red flag seizure, criminal charge, or simply unclaimed property? Step 2. Confirm the identity of the law enforcement agency holding the firearm, for example, city police, county law enforcement, state police. Step 3. Prepare proof of ownership. Under Section 2311, the owner must show they own the firearms/ammunition and that they're not prohibited from possession. Step 4. Submit a formal request to the agency for the firearms return, citing Section 2311 if applicable. If the agency denies the request, note the denial. Step 5. If the denial occurs, file a petition in a court of competent jurisdiction seeking return of the property, as allowed under Section 2311 subsection G. Step 6. If the firearm was relinquished under a red flag/Section 1448C order, then once the basis for the order is removed, request timely return as required by statute. Step 7. Document all communications, keep copies of the request and any court filings, and monitor time limits, for example, notice periods, petition deadlines. Step 8. If the firearm was unclaimed for 6 months after notice and the agency disposed of it, the statute may not allow its return. Here are a few important caveats and tips for anyone seeking return. Even if you submit a request, you must show you are not prohibited from possessing firearms under Delaware law. Under Section 2311 subsection 1, the burden is on you. If the agency has already lawfully disposed of the firearm after 6 months unclaimed with notice, you may no longer have a return remedy. In the risk-based seizure context, if you are subject to a prohibition, for example, mental health or danger to others finding, the return is contingent on you being no longer subject to that prohibition. The statutes focus on law enforcement agencies holding custody of the firearm. If the seizure is in a criminal case, there may be additional processes or forfeiture statutes. This script covers only the statutory return process. This is for Delaware state law. Federal issues, for example, prohibited persons, interstate transfers, may also apply. Always consult qualified legal counsel in your jurisdiction for your specific situation. To wrap up, in Delaware, if your firearm is being held by law enforcement, you have statutory rights under Section 2311 to request it back, provided you show ownership and eligibility. If your firearm was taken under a threat of danger order, you have recourse under Section 1448C once the prohibition is lifted. The key is understanding what statute applies, preparing the required proof, and taking timely action for the return. If you found this helpful, please like, subscribe, and hit the notification bell so you don't miss future breakdowns of firearm law procedures by the right slant. Thanks for watching, and stay informed, stay safe.